Hello, this is new episode of EuroIntegrators program, and we speak today about new disinformation law proposal from Ministry of Culture. That's why we have two guests in my studio today. It's Matthew Schaaf. It's Freedom House in Ukraine. Hi.
Hello.
And Oleksandr Burmahin, a very famous media lawyer from NGO Platforma Prav Людини. Hi.
First of all, I would like to present very briefly in slides what this law is about and why it is discussed in all the talk shows during the last week. The first idea that has raising big questions is the Information Commissioner, who will be dependent on the Cabinet of Ministers of Ukraine and who can go to court to demand from the media not to spread some information. This is a new definition that will appear in Ukrainian law if this draft law is adopted. And not everyone agrees with it. The second question is that every media has to go through a check, has to get a trust index and publish it. And if it doesn't publish it, it will receive fines. The third innovation: journalists have to create a journalistic self-government. The Ministry of Culture calls it like that. But in fact, most of these organizations, which have to create an association of professional journalists, dependent in one or another way on the state or on the large media holding companies. The fourth innovation is fines. There will be fines ranging from 1,000 of minimum salaries up to 2,000 of minimum salaries. I'd like to remind you that this is approximately from 4.7 to 9.4 million hryvnias. That is, almost every media, except very large media holdings, will likely go bankrupt after the first lawsuit. The fifth innovation is criminal responsibility. First of all, it can be minimum up to 2 years of corrective work. It applies to journalists and also can imply huge fines. Another option of criminal responsibility, if it is done by an organized group, for example using the services of bots, is from 2 to 5 years in jail. If these actions are funded, then from 3 to 5 years in jail. And the biggest and worst criminal responsibility is from 5 to 7 years. If these actions are made by parts 1 and 3 of this article, committed repeatedly or by an organized group, from 5 to 7 years, and also restrictions on the rights to engage in activities or occupy positions.
What all of you think about these ideas, and what is your position?
Thank you. Thank you for inviting me to speak with you and for talking about this very important topic. I'd like to start by just saying that the problem of disinformation is very real, and one that not only Ukraine but many other countries are struggling with and trying to deal with. We can see very clearly in the U.S. that this has been a major challenge in many other countries. So it's something that we need to find a solution to, or solutions to. That being said, Freedom House and many other human rights organizations have many concerns about the proposals that have been made. We shared some of these concerns with the Ministry of Culture, Youth and Sport in December, and we'll continue to engage in that process. I think the first concern was about the process, that essentially some pretty extreme proposals were made without sort of adequate consultation and discussion with media, with civil society, with consumers of media, with regular people who this will also affect. Now, fortunately, they have relaxed the timeline a little bit. So originally, the law was supposed to be introduced by the end of last year. And now there's a little more time to have a discussion about this. But from the public events that I've seen, it's not clear that the discussion is authentic and that it's authentic consultation, but more a presentation of perspectives and not a lot of listening and making adjustments based on that. And then I would highlight two other concerns that we have, which doesn't cover everything, but two main concerns. One is the Information Commissioner. This, according to the draft, is a very powerful person, a very powerful office that, but actually has a function more like law enforcement, actually, to be determining what is accurate information, what is inaccurate information, and then recommending sanctions based on that determination. So they have a lot of power over who says what. and what ideas, opinions are considered to be accurate or inaccurate. And then there can be very real consequences. Fines, very high fines that you mentioned, criminal responsibility, potentially jail time for people who offend this law repeatedly. And the person is appointed by the cabinet of ministers. So essentially, they're a representative of the government rather than a representative of the people or of the people's interest. And so it's a political position, and they will have to make some very hard decisions. So there are a lot of questions about the independence of this person. And whether the decisions that they make could be considered legitimate or not. Another area that we're concerned about is the definition of disinformation. And in particular, they talk about disinformation in areas of public interest. So national security, the health and safety of the nation, and some other areas. We're concerned that by singling out information, by singling out ideas and opinions in specific areas like this, that it would actually damage public debate in Ukraine and public discourse on some really important questions. And of course, people's ideas on the health and security of the nation should be actively discussed in the media, on social media. These are the things that are most important to have a vigorous public debate on, and we're concerned that this proposal could negatively affect that.
What about the Professional Journalists Association, which they propose?
Yes, it's kind of ironic to call it self-regulation when essentially a new non-governmental organization would be created by law, and then the function of this non-governmental organization would be highly regulated, also by law. One aspect of this association that I think is especially of concern to us is the distinction between journalists and professional journalists, and essentially only professional journalists who meet some criteria established by the law and also established by the association and its membership at some point in the future get certain rights, including protection from violence, for example. So you're a freelance journalist, you're a journalist who's only worked 2 years and 11 months, for example, as a journalist, and under the current draft of the law, someone threatens your life or attacks you or something of that sort.
Or even killed.
Or kills you, then you won't get the same protection that a journalist who has worked 3 years and 1 month and has gone through the process to become a member of this association and so on. And so it's kind of an arbitrary distinction, and one that can very seriously affect the work of journalists in Ukraine.
Oleksandr, I saw that you wrote a great analysis. It's too long for us to show its own 22 pages, but we've pointed out the basic recommendations from it. Could you tell us what exactly you didn't like in this law, what it violates, and what can be left from it?
Вам не сподобалося в цьому законі, що він порушує, а що можна залишити, можливо?
In fact, I want to emphasize that 4 lawyers have worked on it, a human rights platform and a digital security lab. These were 4 quite experienced media lawyers, and we emphasized the main things in these recommendations in this analysis. Because if we wrote about some smaller concerns and then write the recommendations and conclusions, then this document could take up the same amount as this draft law itself, for about 100 pages. In fact, the key or basic models offered by this draft law by the Ministry of Culture have either contradictory to the Constitution or contradictory to both the Constitution and the Convention. Or it contains serious flaws that also contradict international standards and approaches or the practice of the European Court of Human Rights. If we take a commissioner in the informational sphere who is planned to be appointed by the Cabinet of Ministers in accordance with the Constitution, has no power to create such an institute. It manages the executive branch of power, and regarding the commissioner, there is a large volume of international standards that provides for minimum standards of independence and the professionalism of this person and this institute. And most importantly, The ombudsman should protect the rights and not persecute journalists or other possible human rights abusers. That is, should protect common interests. The ombudsman should protect the rights and not persecute journalists or other possible human rights abusers. That is, should protect common interests. The ombudsman primarily protects individual human rights or groups of people. If we take the definition of disinformation in general, it's one of the major defects or disadvantages of this whole complex, because it's positioned as anti-disinformational, and in fact the definition of disinformation given in this draft law is that it is untrue information on socially significant issues in the field of defense, national security, environmental protection. There is a right to self-determination for some reason and territorial integrity. Our organization, our lawyers, are now defending cases of Pashinsky before Novaya Vremya regarding the publications related to the defense sphere. I'm running now the case of Gladkovsky-Svenarchuk against Bihus and his team. We all remember this investigation that became a blast during the election campaign. Such investigations will automatically fall into a category of disinformation, as journalists often use information obtained from their own sources on the basis of anonymity. This draft law and this concept implies that all information should necessarily have sources and must be from identified disseminators. And the disseminators can be any person. It's applied that, for example, the use of aliases is forbidden, which also doesn't meet journalistic standards, doesn't comply with the law on copyright and related rights. That is, any investigator who disseminates disinformation accordingly falls under the sanctions that were already mentioned. This is also a certain nonsense. However, such a definition doesn't cover the huge amount of disinformation that is being addressed today in international researches, in Council of Europe documents, in European Union documents. It's understood that when reliable information is mixed with unreliable information, even authentic information is given with certain accents and is essentially used for negative purposes. And today, there is an understanding among international organizations that disinformation is a larger process. It is an action, not a category of information. And this draft law, which contains such serious sanctions mechanisms, is essentially narrowed down and can only be used in the internal market to our own journalists. Although, if we talk about disinformation about this issue, it appeared in connection with an external threat. International organizations today say that the source of this threat is Russia, Iran, North Korea, China, and other countries, but these are the main four countries. But then these mechanisms should also be focused on the fact that these are external threats, these are narratives. This is a great analytical work and not a narrow enough definition that can be interpreted one way or another, again without clear criteria. It's narrow, meaning by these manifestations of disinformation. Again, if we talk about this journalists' association that is planned to be created under the law, there is a confusion in terms even among experts, because many of them are talking about self-regulation, and they have written it as self-government. And the mechanism itself is essentially borrowed from the lawyers' self-government. Why do journalists need lawyer self-government? Advocacy has its role in the society, its international standards, and indeed, according to them, there should be corporate self-government in the advocacy. There are no such standards and practices for journalists, and they have written that it's the only organization that deals with these issues that cannot be eliminated, cannot be reorganized, and they even prescribed every step how it works and functions in details. There is already a violation of standards in the field of freedom of association and association of citizens. Is this constitutional freedom already? Yes, but they violate the Constitution in another aspect. This aspect is related to the fact that we have two classes of journalists. They restrict the rights of other journalists, professional journalists and just journalists. And the difference between them is only that some of them are members of this organization and others are not. And in essence, a large number of professional rights and guarantees will depend on this, and this will turn into privileges for the professional against the non-professional journalists. This is a direct violation of Article 36 of the Constitution, because according to our Constitution, there can be no different amount of rights and powers depending on the presence in public associations, and they're essentially trying to enforce this. The most obvious thing is that all the specific guarantees of criminal protection will apply only to professional journalists. That is, if someone attacks a journalist, violates his professional rights, an ordinary journalist will have no protection, and, for example, accreditation. Only professional journalists who are members of these organizations can be accredited. The ordinary journalist who doesn't want, and he has all the right not to become a member of this association, which is also a constitutional standard, he won't be able to get rights because he simply won't be accredited. And by responsibility, there are absolutely disproportionate things, millions of fines that will create a cooling effect for sure. And concerning the commissioner, again, the labeling of materials is essentially forced, because when the commissioner addresses and says that in his or her opinion it is disinformation, then every media or distributor should mark such news with the fact of disinformation, or that this issue is considered as disinformation. And then those who are posting this information are obliged to show and save it as marked. As long as the process goes, a lot of media will be essentially having marked information. And most of the anti-corruption investigations, I think, including them. And the most interesting thing that we discussed with our colleagues, this can be used as a trolling. And the media that work legally can suffer. Online medias which are registered in Ukraine, which are not hiding somewhere on islands by their hosting, because those medias will ignore those requirements. And those who are really working, Obozrivatelь, Liga.net, such large publishers can have marked information due to such trolling.
По суті, кожну статтю можна через такий тролінг помаркувати, і вони будуть завішені всіми цими плашками.
Another guest will be joining us now by Skype, Solomia Bobrovska, the deputy of the political party Holos, the secretary of the Parliamentary Committee on Foreign Policy. Solomia, hello. Hello, good afternoon. We've seen statements from 3 international organizations. This is the European Federation of Journalists, Arlem Désir's office of the OSCE, and the Council of Europe, which supported the position of the European Federation of Journalists today. Tell us, how do you expect this draft law will be welcomed by international partners? Well, first of all, I would like to say that we are also preparing our own statement from our fraction Holos. Obviously, we are also ashamed. And it's very strange that colleagues who work in the media environment and spoke before the elections that the National Council, in particular, would have all possible resources within the National Council in relation to the control of conditional disinformation. But there are opportunities that the National Council can control, for example, giving the license, withdrawal it, and so on. But today they are issuing a very strange draft law that looks more like a document of Belarusian format than the Ukrainian one. Because it seems to me that journalists have very clearly shown their position in the past years about the possibility of tightening the knots for the journalistic environment. That's why we must have not only international partners, but first and foremost Ukrainian politicians and also the journalistic community. Because it is politically not just a fight against disinformation. It's certainly the same as with the new regulation that they want us MPs to fasten actually to one quality mark, like they offer a quality index in this draft law, and put us in one line. Well, I would like to see what an interesting state line will that be, and again, it will be similar to the Belarusian format, not to a democratic Ukrainian one. And you think this draft law, as it is now, still can get votes in your opinion? However, we will hope for an adequate number of colleagues from the majority who understands the risks and who also came out of the media. From what I know from the opposition parties, including us, we will not support this draft law, although our position was similar when there was a change in the law on foreign language broadcasting. However, the mono majority voted anonymously for it, but I hope that they will see a lot of risks here. And if someone of them plans to to go into journalism, I'm not sure they want to be as functionally minimal as MPs today. Thank you, Solomia, for your position. Let me remind you that it was Solomia Bobrovska of the Holos Party, Secretary of the Foreign Policy Committee. I think it is wrong if we won't hear the opinion of a ministry representative. We invited them, but unfortunately they didn't come. There had to be fourth chair for them. A deputy from the Humanitarian Policy Committee from Sluga Narodu also declined to come. But we've picked up the main position and the main arguments of the Minister of Culture, Pan Borodyansky, and we wanted to show you, and then we will discuss those arguments. There will be an appeal to the distributor of information, and then a court hearing will be held to decide whether this information is disinformation in the interpretation of the law we're proposing to discuss. That's how it happens. It's not so accurate, but it's not a disinformation. About self-governing organization that journalists will join. We are criticized for identifying the list of organizations that create this organization. I would like to give an example of Lithuania, which has the same organization, and the founders of it are 15 members, consisting of one representative that is delegated from the Lithuanian Center for Human Rights, an association of Lithuanian psychiatrists, the Bishops' Conference of the Catholic Church, the Publishers' Association, the Lithuanian Radio Association, the Association of Journalists, National Association of Creative Journalists, National Association of Publishers of Districts and City Newspapers, etc. The law, like we do have, defines the list of organizations that founded this self-government organization. A journalist can be unprofessional, that is, he can work, collect and disseminate information. But the state says that only a professional journalist has a special function and will receive the additional protection from the state. 7 years is given for the systematic spread of disinformation as a bot farm. The index of trust is the fact of checking. Relatively speaking, the world has fact-checking companies, and they say that this is the media that used facts for a month, not distorted them, and gave factual information. They are assigned an index, and they independently receive this index and say, we are trusted media. The draft law has gaps. It's not perfect. And it has to be cleaned up. But it contains the things that we talked about, that you wrote about by yourself, and we support them. We support the story of being a professional journalist, that he or she should receive professional certification and can be protected by law in your community.
Його треба вичищати. Але в ньому реалізовані ті речі, про які ви говорили, про які ви самі писали. І ми їх підтримуємо. Ми підтримуємо історію, що повинен бути професійний журналіст. Що він повинен спільнотою, вашою спільнотою, отримувати професійне посвідчення і захищатися законом.
So, that was their argument about professional journalists and the index of trust and the commissioner and about 7 years in jail. What can you say as a lawyer about all that? Firstly, a brief comment on the speech of the member of our parliament. This draft law will not only apply to journalists. Anyone who writes their own post on their Facebook page, for example, will be distributor of the information in accordance with this draft law and will be the subject to responsibilities such as full identification according to these sources, links and everything else. If not, such a disseminator will be considered as disinformer, as well as an investigator writing on the subject of defense. Deputies can also be linked to that. Absolutely right. As for the speech of Minister of Culture, the general concept here is that it should be a complex, a jewelry mechanism that has to balance a very large number of particularly sensitive areas for Ukraine today. And indeed, protection of territorial integrity and national security on the one hand, and freedom of speech on the other, freedom of expression in all its manifestations. Protection of privacy can be there too. But for some reason, the authorities, like the previous ones, are planning an X instead of, say, a microscope. Like there was a draft law 6688, if you remember.
Тобто там був законопроект 6688, якщо пам'ятаєте.
Cheer up, the worst is yet to come, compared to this law, as I think. Yes, but for some reason the authorities always offer an X in such complicated things and difficult moments. But there cannot be an X at that, with such uncertain discretion and limitation of criteria, because it will cut and work on internal, let's say so, subjects, rather than on external in the first turn.
Why do you think international organizations like OSCE are so disturbed with this law that Arlem Desir is even coming to Ukraine next week?
I think they're concerned for the same reasons that we are, and that many in the media are, and human rights groups and legal experts and others, that the proposals that have been made could have disastrous effects on freedom of expression, on the work of journalists, on access to information and the ability of people to access, lots of different information, but different voices and different people and so on. So that's the first issue, and where I think the main concern comes from. And then also that there is some twisting of international standards that is happening to a certain degree, and
Twisting? What do you mean, sorry?
so saying that, oh well, this proposal is consistent with international standards, wink wink, like it's not, and that's the point. And so Harlem Desir, people in the Council of Europe, the main holders of media freedom, freedom of expression standards that are relevant to Ukraine, I think have a responsibility to be engaging the government, to be engaging the public, to be speaking, to sharing their perspective on first what they think about the proposals that are made, and also what are the existing international standards, and then how can Ukraine, how can other countries deal with the problem of disinformation, while also making sure that people can speak their mind, have access to information, journalists can work independently without inappropriate influence from the government, and so on. And so I don't know exactly why he's coming, but I hope that's part of it.
About this law, he's coming about this law to have consultations.
Great.
About the law.
And I hope that the government, that Ministry of Culture, that others do engage them and take advantage of the resource of the experts that they have, the lawyers they have, to come to a better solution.
We are also seeing on the screen the position of the European Federation of Journalists now, and today's comment by the Council of Europe. While we are showing the viewpoints of other international freedom of speech journalist associations, I would like to ask, what is the real world practice of disinformation in the world? International practice is still being worked out. That is, there are no ready-made effective models, let's say, that could be implemented with one or another variables to the situation in Ukraine. International practice is still being worked out. That is, there are no ready-made effective models, let's say, that could be implemented with one or another variables to the situation in Ukraine. Therefore, just like other countries and the United States and the European Union, we are at the stage of solving this problem, searching for these models. But again, there are universal standards, cannot contradict with these models, cannot introduce mechanisms that have censorship signs, that will raise the cooling effect and horrification not only of journalists, but also of any disseminations of information. Today, let's put it in this way, international practice is moving through the creation of analytical centers that are serious about exploring these issues and tracking the sources, narratives that are spreading. And then the second part that may emerge is joining these analytical centers. The most famous example is strategic communications, enjoining of national regulations that working in the media field to them, so to speak, to monitor how well the media listens to the results of these analytical centers. Sorry, when you are saying strategic communications, you mean a center of excellence like in Riga or anti-disinformation center like in Brussels? Yes, that was created in 2015, and last year the European Union increased its funding, and when its funding increased, enlarged the staff and actually strengthened it. So to speak, the rhetoric of the European Union and European Parliament changed significantly last year compared to the years 2017 and 2018. They've understood all the dangers and, so to speak, the level of these dangers, and will reinforce all these institutions. Euro MPs saying that such an institution should be present in every country and not just within the European Union. Because those countries that disseminate this disinformation and use international technology are essentially making democracy versus democracy. They spend far more money on these tools to use them, so there must be an adequate response. But again, it has to be a jewelry mechanism that will balance all of these sensitive topics, not an axe, for sure.
What is your organization thinking about instruments in other European countries? Because Minister Borodyansky is claiming that in the UK there is anti-defamation court, in France there is anti-disinformation law, but this law is actually absolutely different without no prison for journalists. What is your organization thinks about such instruments?
So Oleksandr is absolutely right that there's no sort of one best practice or standard in dealing with disinformation. But there are many things that can be done, and we've talked about it a lot in our report, Freedom on the Net, which is specifically about internet freedom in Ukraine and in many other countries. Because one of the main conclusions of the recent report is that that democracy will depend on how we deal with these questions and disinformation and social media and other things. So it's great to hear the minister talking about fact checking. Fact checking is essential; it needs to be a part of the solution, but not fact-checking that could lead to sort of criminal sanctions and other types of things. Fact-checking should be independent, and it should help educate people and inform them rather than be part of a sanctions system to hold people accountable. Education of media consumers, of people using the internet, which is a part of the disinformation concept, and that's good. It should be part of the formal education system. There should be informal education on being able to tell what's fake and what isn't. Only 11% of Ukrainians, I think, were able to discern fakes based on a survey or a study that was done by Internews. So those are two areas. One other thing that Oleksandr had mentioned earlier is not focusing on content, but focusing on tactics and acts of disinformation. So disinformation can be any area. It can be in national security, it can be on health issues, it can be on political issues, on anything. So we should be focusing on bots and things of that sort, and developing a policy that will protect against those types of actions, rather than singling out specific areas of specific topics or types of news or something of that sort to be developing a policy.
But tell me in a conditional way, if some alternative draft law will be adopted to the French one, do you think will it work in Ukraine? The French law, first and foremost, is about elections only, and these are extraordinary procedures that only relate to the election process. Well, 3 months before the elections, I was told by a French MP who drafted this law that they have elections almost every 6 months. Therefore, it will work for 6 months, and then for 6 months it won't work. I think that this experience is practically absent at the level of the law. It is indeed can be Germany, but again, they criticize these approaches. In essence, France could be more at the level of legislation. Well, Malaysia seems to be, but this is not a good example. Russia and North Korea, China and Belarus.
Китай и Белоруссия.
Just those ones who are using disinformation as a tool of international influence. The most important point is to start a discussion with the analysis of the problem, because in fact everyone speaks about disinformation, but they put their own meaning into this. And there were discussions when we worked on the media draft law questions regarding our National Council. And industry officials said, please, tell how many facts of disinformation were there. And there was no answer. Everyone was mentioning some high-profile cases, but there were 5 or 4 in a period of last 5 years. Where's analytics? Where's understanding? What? How? In what ways? And so on. It then depends on the mechanism itself and the tool to prevent it. Well, look at Stop Fake. There are over 100 different fakes that they at one time denied. I remember 100 in 2015. Text.org made a great tool when they analyzed the sites that reposted much from Russian sources. And they showed what percentage of false information was on those sites.
Був на цих сайтах, і я б, наприклад, якщо в мене
On Russian sites, on Ukrainian sites that reposted Russian sources. And if it could be an application on my phone that would allow me to watch, for example, if I Google 10 links, that I could see immediately what percentage of false information this site had, I would install such an application. But it all shouldn't be forced. And these disclaimers on every site.
відсоток неправдивої інформації має цей сайт, я б поставила собі такий аплікейшн. Але це не має бути примусово з цими дисклеймерами на кожному.
My colleagues and I discussed this when this draft law from the ministry appeared about all these markings and index. In fact, if an analytical center was created to provide analytics, what sources are reposting and redistributing in Ukraine, for example, Russian sources, there would be a general idea to create a register of disinformation sources in Ukraine for everyone to check and see, but it should be also the proper procedure, guarantees about the possibility of reviewing this registry, and exclusion, not only the inclusion, and the order of inclusion should be developed, but not obliging all Ukrainian media mark these materials, which in the opinion of the commissioner are disinformative. By the way, regarding to minister's speech, he spoke about judges and so on. These are only criminal cases. There will be a large number of actions at the administrative level without a court decision.
Буде на рівні адміністративному, без рішень судів.
So there will be the commissioner only. Yes, the decision will be made by the authorized person. And if you disagree, you can then go to court to appeal his actions. That is, the guarantees he said about judicial protection, they concern only criminal prosecution.
What do you think? It will be possible to pass this law proposal in today's position, or maybe in more calm version?
I think that neither the first nor the second variant is acceptable today. In my opinion, and as I also spoke with my colleagues with legal experts, firstly, there should be no unnecessary motions in our opinion. There should be a professional discussion in the first stage. The common touch point is that this problem exists, and it's disinformation. Almost everyone agrees that this problem exists. The second point that should be discussed at the level of specialists in different fields is perhaps the creation of a working group in one format or another. To take 2-3 steps back and to start working on how to solve this problem. But first, to formulate this problem as it really is today, in what manifestations and what meaning we put into the content of the word disinformation. And stage 3, it's already directly working out of a new possible draft law with the possibility to take certain things from a previous one. But well, let's say not more than 15-20%, and it's something that can be borrowed when creating a new regulation. 15-20% is rather a good amount, as I think, for the first draft law of the Ministry of Culture.
Well, considering the fact that this is a very important issue that does need to
Be addressed.
Needs to be addressed. There's more that the government can be doing, the more that the public can be doing, the media can be doing to address this. So. Whether this particular law is, well, I've been very clear that this particular law does not seem to be the right one for solving this problem. It's hard for me to tell what the politicians will do, and the response that we've seen from various different political actors has not always been clear, and the willingness to receive criticism, to process the criticism, and then make changes is also unclear. So there's a lot of concern that this law will be passed in a version similar to the proposals, and I think that would be a mistake. But I hope that we can use this as an opportunity to actually have a real dialogue that feeds into real solutions that make the right balance between the nature of this challenge and also the fact that this has a lot of impact on the growth and strength of democracy in Ukraine. And you can't have a democracy where people are scared to express themselves or media can't function and so on. So the potential impact is enormous, and so the discussion, the consultation, and the development needs to be taken very seriously.
In my opinion, it is clear that there may be a political will and the majority of the parliament, the mono-majority. But in my opinion, if there is an attempt to lobby this draft law in such variant or in a softened but basic one, then it will lead to open confrontation with the public, with media journalists, because despite how divided they are today, this question of such threats will unite them all.
Тому що, не дивлячись на те, наскільки є розрізаним на сьогодні цех, оце питання і такі загрози, вони об'єднають всіх.
Let's hope that our government and Ministry of Culture will understand that it's impossible to save democracy with undemocratic methods, and they will withdraw their law proposal or change it almost completely. Actually, the new government and new president came with freedom of speech idea and with supporting of journalists. Journalist investigation actually helped him to get his percentage. So let's hope that they will understand that that's a wrong way of uniting all journalists, foreign partners, farmer parachabots, and all other people against this law. So thank you for joining this program. Thanks to all who watched us. See you next week.